that being operating a vehicle under the influence of alcohol, drug of abuse, or a combination of them, a felony of the 4th degree in violation of Revised Code Section 4511.19A1A. The case was then referred to the Adult Probation Department for purposes of a pre-sentence report and investigation and drug and alcohol evaluation. Those have been completed, and we are here today for purposes of sentencing. Defendant is present with her counsel, Mr. Richard Perez.
Thank you. Mr. Perez, any reason not to go forward with sentencing at this time?
No, Your Honor.
Anything you'd like to say on behalf of Ms. Burrington?
Yes, Your Honor, but I think I'm going to have, I think you have some letters. I think Mr. Burrington would like to address the court, and my client would like to address the court, and I think I'll come last.
Okay. So whoever's here that would like to speak on behalf of Ms. Burrington, you can stand where you are, state your full name, and say whatever you'd like me to know.
David Burrington. Good morning, Your Honor.
Good morning.
Just to give you a little background about my sister Mary, she's been diagnosed with MS for over 20 years, clinically diagnosed. She's been dealing with it. It is her personal prison. She's had a hard time dealing with it psychologically, more than anything, I would say. Before she had her condo 20 years ago, I was taking her out and showing her places to rent, buy, and stuff like that. She would fall all the time. She's been medicated for her disease. I just think psychologically it's kept her imprisoned in her own mind, her limitations. I think that she uses her alcoholism to kind of cope with it in her mind. I know it's declined relationships that she's had. She does have a problem, and I think some serious jail treatment would help her and benefit her, along with mandatory psychological evaluations. She's just always had a hard time dealing with it. She's a great person normally to deal with. She takes care of elderly people. She's taking care of my sister who's in stage 4 cancer right now that couldn't be here today, that she's been in treatment for the last 2 weeks. She's got lung cancer and brain cancer, and she's been staying with her. And she's helped my mom in the past, who basically needs a knee replacement, but she's got heart problems, so she can't have that replacement. Well, I say that, I mean, she's got to take responsibility and accountability for her actions, and I understand that. I just want you to know from my perspective, I think that her problems stem from having the MS and witnessing that and dealing with that and helping her. To give you an example, Your Honor, when she was last in your court, she called me that night because she couldn't remember anything that happened in the court. Today on the way here, she was worried about phone numbers. She took a pen and wrote phone numbers because she won't be able to remember them. That's how bad her cognitive ability is. Her physical therapist, this is kind of funny but not, she told me this, it blew my mind, said, you should try walking and chewing gum at the same time. I'm like, my exact words, I said, are you fucking kidding me? That's what they told you? And she's like, yeah, that's what they told me. So I just want to put that out there. I understand that you've got a job to do, and I respect that. Thank you, Your Honor.
Thank you, sir. Mr. Perez, is there anyone else? Mr. Perez, no, aside from your client, is there anyone else?
Do you want to say anything to the court?
No, Mr. Perez. Anyone else over here?
Oh, no, Your Honor.
All right. All right, Ms. Burrington, then you do have a right to speak and address the court before you're sentenced if you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I thought I would have it all in my mind or written down on paper, but I figured I'd just have it come from my heart. And what is on my mind is that I am so sorry and beat myself up for what I did. I was sober for 11 years. I know how to stay sober. I would tell you things that I should have said before that I didn't in the courts, but it's irrelevant now. I wasn't in my car when I got arrested, and Menor had a bunch of lies, but...
Menor what?
Menor cops did not do their job correctly, Menor Lake. But that's irrelevant now.
No, it's irrelevant. You pled guilty. We're not here to argue about whether you did this or not. You did it.
I just want you to know that I'm sorry that I did that, and I'm sorry that I did drink and let my emotions get the best of me. That I do try to do the best things in life, and I'm just, I don't want my life to be over with, but I feel like it is because I am not any younger, and I'm just so unhappy with myself, and I'm so sorry for being in front of you in this court again, Your Honor.
Is there anything else you'd like to say? You don't have to. I just want to make sure you've said everything that you want to.
I just want you to have mercy on me. Some understanding. I'm grateful for your time today. Thank you.
Thank you. Mr. Perez.
Thank you, Your Honor. Judge, we submitted her medical records to you, so you know she's had MS for a number of years, and my brother just told you the same thing. The MS has caused mental decline in her, depression, and just dealing with MS affects her physical and her mental, and causes her to be depressed. And I think at this time in her life, when all this happened, I know she's been trying to stay sober for years. When we look at recidivism here, I know she has a history for recidivism. It's very old. She hasn't had an OVI for, I don't believe, 13 years. No other real criminal history. I think when she was young, she had a resisting arrest or something like that, or an open container. But basically, she's led a law-abiding life other than having a problem with alcohol and driving. Right now, she doesn't have a home. She, makes, I think, around $1,500 a month from Social Security. So she lost her home. She lives with her sister now, who she's been taking care of, who has cancer, as indicated by Dave. She has a grandson who she's been taking care of for a number of years because he has an eating disorder, which affects him physically and mentally because he doesn't get the nutrients that he needs. So she's been taking care of him. He's 23 now. So as a result of losing her house, issues with her grandson, she also helps take care of her mother and her sister's cancer, and just the overall depression from MS and I guess her life in general. She did start drinking again, and she is remorseful for it. I think she's indicated that. I don't know that, I don't know the extent of her alcohol use because I can only talk to her about it. I don't see it written up in the medical records that there's an issue with her alcohol use. She is functional on a daily basis. She has driven without being arrested other than this OVI when she got her license back. She has to exercise every day. She has to do certain things. She's on medication that helps her out.
After 5 chances and endless excuses, the judge finally snaps, and his words leave the courtroom in complete silence.
Days in jail, and I would ask the court not to give her any more jail than the minimum mandatory required. She has spent 13 days in jail already. I would ask the court to give her credit for that. I would ask the court to fashion some sort of program where she can, she can't drive. She lives in Brook Park. It's going to be difficult for her to do anything in this county. If the court is thinking of some sort of residential treatment, I would think Oak House would be probably the best place for her. There would be other individuals, maybe her age, and her level of maturity. And she does have a desire to not drink, stay healthy, and wants to be part of society. She knows she'll probably never drive again, which is going to be very difficult for her because she does have various medical appointments. And being a caregiver, and she did work as a caregiver on the side, while this was going on. She's limited as to what she can make on SSI or SSD. So she was able to work a little bit. She did got a SDA certificate. So she tries, but I can't really imagine what it's like to live with MS and not know what the next day is going to be like, and the depression that it causes, and with a history of maybe getting an outlook or or a release from drinking, which unfortunately is something she's dealt with, as you can see from the report, since she was a kid. And she needs to learn another way to deal with all these things, and she's hoping to do that. So I would ask the court, obviously not to send her to prison. I know there's a recommendation for community control. We would ask the court to accept community control. If the court is thinking of some sort of treatment, I know she's agreeable to going to treatment. She has been in IOPs before. It is going to be very difficult for her to get around. If the court is thinking of maybe something like Oak House, that might be pretty palatable under these situations. So leave it up to the court, Judge.
Thank you, sir. All right, Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, as I indicated at the last hearing and chambers as well, the state is not opposed to community control sanctions despite the prior prison. Looking at her history, she does have a history of OVIs clearly, but it has been some time, and sometimes since her last criminal involvement. The issue is that she was belligerent here with people at the pizza shop, and that's why the police were called. She ultimately admits to drinking 4 beers and 4 shots, but had her behavior not been that way, they would not have ended up calling the police. Police were very, very cordial with her the entire time. Despite some of the things that she said, despite saying some crude things about her grandson, they still went. And in terms of watching the video, they were very, very good with her, very kind with her, and clearly the MS didn't cause the smell of alcohol. And the 4 beers and the 4 shots that she told them that she had, whether or not it was more or less than that, I don't know, but that's specifically what she told them. So in terms of looking at that, looking at the fact that it does indicate that there's alcohol use disorder, and that her treatment was many years ago. I know that she's done jail treatment and IOP twice, but here, and the state was recommending NeoCap originally, but I understand pursuant to our conversation in chambers that that's not really probably going to be feasible. So jail treatment with some kind of sober living as well. Definitely mental health evaluation and following the recommendations and some individual counseling, whatever else the court does deem appropriate. She does have 12 days of credit for time served, as far as I know, not 13, and we would ask that you impose the requisite driver's license and the mandatory fine as well. Thank you.
Thank you. Court reviewed the pre-sentence report investigation, the drug and alcohol evaluation, considered the facts and circumstances of the offense involved, the nature of the offense. Received a letter this morning from a sister. I read that. I've considered what's been said here in court by the defendant, her lawyer, Detective Burrington, the prosecutor, the recommendations. All of this is considered by the court in light of purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing makes it more or less serious. For the recidivism factors, the court notes there is a history of criminal convictions in terms of non-OVI offenses. There were some offenses that were over 30 years ago, misdemeanors. In regards to OVIs, however, this is now her 6th conviction for OVI. She's not responded favorably in the past to previously imposed sanctions. She was on probation before. Violated. There's no genuine remorse in regards to the offense itself. In fact, she denies that she did this. She pled guilty. But the probation department, she denied that she committed this offense. Even here, she's casting blame on the police department and others. As for factors indicating recidivism is less likely, the court does note the defendants led a law-abiding life for a decent number of years. The last OVI, albeit there's 5 of them, the last one was in 2012, the incident. So, 13 years in a couple of weeks from the last time she's got anything. So that indicates recidivism is less likely. Under 2913B1, the court knows the defendant has previously served a prison term. That overrides any presumption for community control, permits the court to impose a prison sentence without having to make any special findings. At this point, despite the defendant's denial of doing this, which always causes issues when we put someone on probation when they don't think that they did anything wrong, but I will find that prison is not consistent with the purposes and principles of sentencing, and she's amenable to an available community control sanction. So I'm going to give you a chance, but you're going to have to accept the fact that you are guilty of this offense, you did it, and you need to move forward and look forward and forget it's irrelevant at this point. You even said it was irrelevant, and it is. Pled guilty or found guilty, you're being sentenced. You got to take advantage of what we're going to do here to try to move forward. I'm going to put you on community control sanctions for a period of 2 years. As sanctions, I'm going to order 90 days in jail. If credit for 12, I'm going to order, however, that after you've served 60 additional consecutive days, which is what the law requires, that you can be released at that point upon a bed becoming available at Oak House or Nevaeh Ridge. You're recommending either one, right? Whichever is available first?
Correct.
So if there's a bed available on that 60th day, you can be released on that day and go. If it's going to take a few days, the extra days is to just make sure we have some cushion to get you into the program. So anytime after serving 60 additional days or 72 total, she can be released once a bed's available at Oak House or Nevaeh Ridge. The balance of the jail time will be vacated. And while you're in the jail, you have to do the jail treatment program. Successfully complete that program. Then enter Nevaeh Ridge or Oak House, complete that. Successfully follow all aftercare recommendations. Then you shall complete sober living for 6 months. You're not to use any drugs or alcohol. Submit random testing when requested. All those tests must be negative. Positive test result will result in probation being violated. To attend 3 AA meetings a week. Have a sponsor. You only have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine as well. But whatever doctors prescribe you medication, the probation department needs to know who they are. You can only get prescriptions from those doctors. You can only fill them at one pharmacy. They need to know where that is. You're to sign any releases that they need so that if they want to reach out to any of these folks, they can do that. Wanted to start back up with mental health counseling and evaluation, follow whatever recommendations are made for any type of counseling. Pay court costs and supervision fees. There's a mandatory fine of at least $1,350 that has to be imposed, and I'll impose the minimum. Suspend your driver's license for 3 years. Jennifer, anything else I'm missing here or you can think of?
No, Your Honor, thank you.
Not that I'm aware of, Judge.
I'm sorry?
Not that I'm aware of.
So, Ms. Burrington, you understand the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise if you fail to comply with any of these conditions and the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while on probation, a motion to terminate your community control sanctions will be filed. It's found that you violated, could extend your probation up to 5 years. I could use and order more restrictive sanctions, which could include jail time, or I could terminate your probation and send you to prison at that point. And if I did that, it would be 30 months in prison. So that's what you have hanging over your head. You understand that?
I understand, Your Honor.
All right. I want a condition of probation to also be that there's no driving. I know I suspended her license, but a lot of times it doesn't come to our attention unless there's a DUS charge, and that's still not to drive. You understand that?
Yes, Your Honor.
Sometimes, justice isn't about punishment, it's about realizing your last chance just slipped away.